Hello, everybody. Due to the prevailing situation of our country, we will not be able to meet regularly and go through the presentations and conduct the lectures as usual. So, Slim has initiated this learning platform where we can deliver the presentations from a remote location. So, this is the pilot project that we're trying to do. So I selected a small area which we couldn't cover last time. If you guys can remember, last time when we met, I did the assignment briefing, and we had to cover entry methods for the assignment. So I skipped the legal environment and moved into entry methods. I briefed you on the assignment, and I'm sure you can use these few days where you're spending a lot of time at home to complete, at least to complete your assignment. So any queries that you have related to the MGM assignment, you can direct it to me on Facebook. So I will be able to help you out with any gray areas. But I think the assignment briefing was comprehensively done, and the subject area, the theory area, which is related to the assignment, was completed. So if I go back to chapter 4, from where we stopped at the political environment, we completed the political environment. If I give you a recap of the political environment, we learned of the different political motivations of host governments and home government. If I uh, uh, put that into a nutshell, the main motivations that any government would have would be national sovereignty and the goal of self preservation, need for national security, fostering national prosperity, enhancing prestige, promoting ideology, protecting cultural identity. These are few of the political motivations that any government would have. So, as international businesses, we should never challenge those political motivations. I gave you examples from China, say Huawei, how Huawei faced a lot of challenges in the West due to certain political, ideological clashes, right? We learned of many such examples, ideological wars, promoting ideology. If you look at North Korea and South Korea, we see South Korea promoting the capitalist ideology, whereas North Korea is promoting mainly a more communist kind of ideology. So there are main political motivations that are very much common to any government, whether it's a host country or a home country. You have the same political motivations, overriding political motivation. And then we learned of three things. One is the political ideology, then number two, political stability, number three, political risk. Political ideology is the philosophy of the ruling party. Political stability is the stability of such policies. And political risk is the changes that are happening in the political environment, which will have a negative impact on businesses. So, if I go back to political ideology, there are different ideologies like capitalism, socialism, communism. All these are different ideologies that you see. There are different government types like monarchies, absolute monarchies, constitutional monarchies, federal systems, democracies. So these are different government types that we see. So stability is, we said stability is more important than ideology because stability has an impact on economic performance, right? So if there are stable policies, there will be investor confidence. When there is investor confidence, there is more foreign direct investments coming into the country, and finally, it will have an impact on the economic growth. Finally, coming into political risk, we learned there are different types of political risks. That it can be government ownership restrictions, operating conditions, Um, then it can be takeovers. Takeovers, we learned there are three types of takeovers: confiscation, expropriation, and domestication. Government might ask their people to boycott foreign firms. That's another form of political risk. And we also learned of how to overcome this political risk, right? What are the steps international companies, foreign firms should take to be politically neutral and to reduce political risk. So these are few things that we learned. So moving into the legal environment, today's slideshow. So I'm not going to tell you any page numbers from the book, but because the book that I have and the book that you guys have might have differences in terms of page numbers. You can refer to chapter 4. Under chapter 4, you have this section called legal environment. So that's the area that I'm going to cover today. So when you look at the international legal environment, there are three types of laws that you have to be concerned of. Number one is the international law, right? So if I give you an example of a Sri Lankan company that is hosting their business in India, the host country law would be the Indian law, home country law would be the Sri Lankan law, international law will be the international laws that are applicable to both these countries. So if I give you some examples of international laws: human rights, the labor laws, then intellectual property protection. These are all international laws that govern all the countries, right? So both the host country and the home country will have to be in line with those international laws. If you look at international carriage of goods, that again is an international law. Say Hague-Visby, there are different laws that are governing the international carriage of goods. Who is responsible? Say if there is a sudden storm, force majeure, the ship sinks. Who's liable? Who's responsible? So all these are international laws that are impacting both the host country and the home country laws. So when you do business, you have to be mindful of those international laws, and then the country where you're hosting your business, there is a legal system, and then the country where your business is originating from, you will have to comply with those legal systems as well. So if I ask you a question, which legal system, now if you look at this example that I gave you, a Sri Lankan company hosting their business in India, which country's legal system will apply if there is a dispute between India and Sri Lanka? So the answer to that question is it can be the Indian legal system, it can be the Sri Lankan legal system, or it can be a third country legal system. So when you get into a contract, when you get into an agreement, it's important to mention the country, the law that applies, the country in which the law that applies if there is a dispute. So in the agreement, if you have said it's a Sri Lankan legal system that applies, then you will have to seek redress from the Sri Lankan legal system. If the agreement says it's the Indian law that applies, then the agreement will be governed by the Indian legal system. If you don't agree to the host country or the home country, you can always select a neutral country, a third country, say Singapore, and say this agreement is governed by the Singapore's legal system, Singaporean law. So when you get into an agreement, you need to mention the country's law which relates to this agreement, right? Or else the agreement is governed by which country's law, that needs to be stated in the agreement itself. So if you look at different legal systems, we have different legal systems in the world. We have common law countries, code law countries, Islamic law countries, and socialist law countries. So you can get a detailed explanation about all these legal systems from your book, chapter 4, page numbers 88 and 89. These page numbers can vary, I'm telling you again. So go to the legal environment under chapter 4, common law, civil law, code law, Islamic law, and socialist law is explained in the book. So if I come back to common law, now what you see in Sri Lanka is a common law country. Common law is actually deriving from the English law found in the UK. So if you look at all Commonwealth countries still have a common law, right? So if you take India for an example, Sri Lanka, all these countries have a common law because we have been influenced by the British legal system. So the difference between common law and code law is that common law countries, it acknowledges the preeminence of social norms. So law is written, it's very clearly written, but when you get into the courtroom, those written laws are interpreted inside the courtroom, right? That is why when we learn common law, or else when we learn law in Sri Lanka, we always refer to case laws, right? Previous case laws, because a judgment given in a previous case will always act as precedents to the next similar cases that follow, right? So if there is a regulation given, if there is a verdict given in on a similar situation, that will act as precedents to the other following cases, similar cases, right? So that is why common law, we always say it is coming from the society. It is interpreted using social norms, and what society acknowledges as right or wrong is what constitutes the common law. So in common law countries, you will see juries, right? A jury will consist of a segment of the society. You have priests, you have principals, teachers, different people represented in the jury so that they bring in a more social aspect to the verdict. So that can only be seen in common law countries. But when you move into code law, or you call it civil code law is mainly based on the Roman traditions, where it believe in written law, right? The preeminence of written laws. Right? So this can be found in many European countries, and judges play a bigger role than juries in code law countries. Right? So in South Africa, what you see is a code law country. Everything is written, and you go by the written law. There is no interpretation in the courtroom. So moving into Islamic law, Islamic law is mainly based on the Quran, right? And it is based on Islamic traditions. So if you look at both Islamic and socialist law, there are limitations in its application to business situations, because Islamic law is a religious law, right? So if you look at marriage, if you look at social activities, Islamic law would elaborate a lot on how people need to live, what are the laws that are governing marriage. So all that is very well covered under Islamic law. But unfortunately, when you do business, there are limitations. Both, if you take Islamic and socialist law, both have limitations when it comes to doing business. So that is why we see in many Islamic law countries and socialist law countries, they have imported their business law from other countries, right? So that is mainly because of the limitation of Islamic law and socialist law to doing business. So moving into socialist law rises from the Marxist ideological system established in China. Uh, so if you look at Marxist ideological system, you talk about equality, economic power, economic wealth is equally distributed among people. So that's the type of ideology that is behind socialist law. So again, when you have such an ideology, there can be limitations to doing business. So that is why even in socialist law countries, you see business law is now being imported from various other countries because there are limitations of business laws deriving from Islamic and socialist laws. So moving on, now this slide talks about the jurisdiction, or else uh, what can you do when there is a disagreement, when there is a breach of an agreement, right? So before we get there, remember that there are different types of jurisdictions in the world. Now, if you go to the European Union, we all learned that European Union has a single um, uh, judiciary, right? We learn that EU has a common parliament, it has a common central bank, so likewise it has a common judiciary. So we call that judiciary European Court of Justice. So if you have any issue within the European Union, you can always appeal to the European Court of Justice. If there are disputes between governments, there is the UN body, which is the International Court of Justice, ICJ. So these are for disputes between governments. So government to government, if there is a dispute, you can seek assistance from the International Court of Justice, which is a UN, United Nations body. And then if you are a company, an international enterprise, which has a problem with a government, right, a host government or a home government, you can always seek assistance from ICSID. ICSID stands for International Center for Settlement of Investment Disputes. So, say you go and invest in a country, and the government takes over your business without paying any compensation, then you can always file action under ICSID, International Center for Settlement of Investment Disputes. And now taking legal action, we call it litigation, right? If there is a breach of trust, if there is a breach of agreement, you can take legal action, and we call that litigation. So before litigation, there are other methods that you can use to resolve problems. So we call them mediation and arbitration. So if you ask me what are the three options that are available um, during a dispute, number one would be mediation, number two would be arbitration, and finally you can take litigation, right? Why we don't talk about litigation as step number one is because litigation is expensive, especially in international business. Litigation or taking legal action would be a expensive task. So that is why you have to look at alternative methods such as mediation and arbitration. Now, mediation is uh, a non-binding um, solution where an independent third party or a mediator gets involved in finding a solution to the problem. So if you have a dispute, when you get into mediation, what happens is you get the support of an independent third party to help you resolve the matter. But what you need to remember is whatever decision taken during mediation is non-binding. It's non-binding. You don't have to basically uh, listen to, or you don't have to follow the agreement that is being taken during mediation, because it's not an order, right? But you use an independent third party to seek a solution. Arbitration, on the other hand, again, there is an independent third party. We call that an arbitrator. Um, but when you get into arbitration, arbitration is legally binding. So that is the difference between mediation and arbitration. Mediation is non-binding, but arbitration is binding. So if you look at countries like Singapore, there are international arbitration courts where you can actually seek help. So it's always good when you sign an agreement with another party. Um, you need to agree on arbitration courts as well, right? If there is a dispute, where should I uh, go for arbitration, right? Which court, which arbitration uh, court I need to attend to resolve this dispute. So it's better to include all this in the agreement itself. So if you can't find a solution with both mediation and arbitration, then you can get into litigation, which is going to be an expensive task. Again, you will be governed by the the agreement, the legal system which is there in the agreement. Right? So you need to always mention the law that governs the agreement. Moving on to intellectual property rights. Now, this is a big issue that many companies have. Companies that do international business have this problem of intellectual property protection, right? So violation of intellectual property rights is uh, common in international business. Say you go and give a design, you go and give your logo, a symbol, you will see fake products reaching the home country before the original product reaches the home country. So that's the biggest challenge that you need to deal with. So there are a few figures here, might be outdated, but it's good to know. Losses attributed to the violation of intellectual property rights are estimated to be 60 billion a year, and you can see software, entertainment, and pharmaceuticals being the most vulnerable industries to intellectual property violations. So, what has happened is over the past, China, as you know, is a country that is known for intellectual property violations. But after they became a member of the World Trade Organization, they signed an agreement called the TRIPS agreement. TRIPS stands for Trade Related Aspects of Intellectual Property Rights. So, when you sign that agreement, the governments which sign the TRIPS agreement should go back to their country and pass intellectual property laws to make sure that intellectual property is not violated in their respective countries. So China had to sign the TRIPS agreement. We all signed the TRIPS agreement, and we came back to our countries and uh, passed laws to protect intellectual property. So if you look at methods of protecting intellectual property, we can start off with patents. Now, intellectual property can be anything. It starts from a new invention, it can be a original work of art, it can be trademark, anything which is creative, which belongs to your intellectual property. So you have the option of registering those new inventions, copyrights, trademarks, etc. Right? So it's very important for you to know um, what are the intellectual property protections that are available. So number one is, if you have a new invention, you can actually protect the right of the invention as a patent, right? So it can be a new invention. If it's a new invention, you can obtain patents for that new invention. But a copyright is a bit different, right? Now, when you write a book or else you compose a song, you can't obtain a patent. It's not an invention. Instead, it becomes a copyright, right? So, copyright is the right of the owner of the original work of art. It can be literature, music, films, designs, books that you write. For all that, you can obtain copyrights. Moving on to trademarks. A trademark can be a brand name, symbols, mottos, slogans, all that can be covered under a trademark. So this is mainly to protect your brand. Now, if you look at copyrights and patents, patents are for new inventions. Copyrights are for, say, your designs, for any work of art that you do. Trademark is mainly protecting your brand, right? Your brand includes the brand name, the symbols, logos, mottos, everything. Then finally, you have trade secrets. Unfortunately, there are limitations for you to register trade secrets. So, say if you take Coca-Cola, Coca-Cola has a secret formula, secret blend. The moment you register it, it does not become a trade secret. So many companies that have such trade secrets, they don't register, but they have their own method of protecting those trade secrets. So these are few examples of international lawsuits that were filed against intellectual property violations. So if you go into the first set of examples, Polo Ralph Lauren is a US brand which actually started selling under this Polo brand. They are the ones who started the Polo brand. But then the second brand that you see is a Polo brand that is registered in South Africa. So um, when Polo Ralph Lauren came into South Africa, they realized that they were too late to register the brand in South Africa because the South African brand had already registered the Polo trademark in South Africa. So they filed a lawsuit, but they were not successful in South Africa because South Africa is a code law country. Whoever who registered the brand first will own the brand. So if it was another country, in a common law country, Polo Ralph Lauren can actually build a case saying that we have been using this brand commercially, so we need to have rights to that brand. But unfortunately, South Africa is a code law country. They go by the date of registration, written law. So in South Africa to date, what you get is a South African polo, not the original US polo. And then if you look at the second example, Lacoste is the famous French brand, and Crocodile is a Hong Kong based brand. So both these companies actually had a legal battle which was spanning for years, but there was no verdict, a proper verdict given. Therefore, the two companies actually agreed, came into an outside court settlement that they will change their logos. So you might notice that the Lacoste brand, the tail of the crocodile is more horizontal, whereas the crocodile brands, the crocodile's tail is more vertical. So they did those changes, and they changed the direction of the crocodile and all that, and then agreed on an outside court settlement to uh, conduct their business activity. So there are many examples. You can actually research these lawsuits, which are quite famous, and which talks about intellectual property violations. So these can be the factors that actually influence intellectual property violations. I'm not going to spend much time here. So one reason for intellectual property violations can be lack of appropriate legislation. Sometimes the legislation is there, but there is no proper enforcement. That can be another reason. The legal environment really covers intellectual property, but there is no body to enforce the law. That can be a problem. In certain markets, authentic products are not available. That can be another problem, right? The original product is not available, so the fake products actually gain market share. And then another reason can be the high prices for authentic products that limit the accessibility to local consumers to purchase it. So they look at alternatives which are more affordable. So these can be the main factors that influence intellectual property violations. Moving on, this is the agreement that I was telling you about, which was initiated by the World Trade Organization. We call it the TRIPS Agreement, trade related aspects of intellectual property rights. So, the purpose of the TRIPS Agreement was to ensure that there is minimum legal protection for property rights in those respective countries. So every country that signed the TRIPS agreement had to ensure that the minimum standards or minimum legal protection is provided for any international business in terms of their intellectual property. So intellectual property, again, if I get into detail, their patents, their copyrights, their trademarks have to be protected in the respective countries that have signed the TRIPS agreement. So, the World Intellectual Property Organization is also an organization um, which has been established for the purpose of protecting intellectual property. But the difference here is every country that has signed the Patent Cooperation Treaty, what they have done is when you go and sign the Patent Cooperation Treaty and when you become a part of the World Intellectual Property Organization, businesses coming under that particular country will be covered. The intellectual properties of those countries will be covered in multiple other countries because it's a cooperation treaty, right? So, if I give you an example, you can visit the second link that I have given, USPTO, US Patent and Trademark Office. So, US is a part of the Patent Cooperation Treaty. So, if you are a US based international business and you go and register your patent or your trademark under the USPTO, you automatically get protection in 140 odd countries who have signed the Patent Cooperation Treaty. That's how it works. So now in Sri Lanka, what happens is you have a trademark or a patent, you come and register it in Sri Lanka, and you have to register that patent or the trademark in other countries too. Wherever you want to do business, you need to go and register your patent or your trademark. But in US, you don't have to do it because US has signed the Patent Cooperation Treaty with few other countries. So the moment you register your patent or trademark in US, it gets protection in other countries who have signed the Patent Cooperation Treaty. So that's how it works. So attitude towards rules will look at law in a more cultural aspect. So this talks about the perception of people towards rules and regulations. What type of attitude would people have towards rules? So now this will vary from one culture to another. So attitude towards rules are often affected by two things. One is the power distance. Number two is the human nature orientation. So if you look at power distance, what we assume here is the higher the power distance is, people would perceive rules negatively because people would see that there is a large gap between the rich and the poor. There is a large gap between levels in the society. So, when there is a large gap, they don't believe in rules. They always think that rules only apply to the bottom level or the lower levels in the society, but the higher levels will find some loophole and get out of it. They might use their contacts, they might use certain loopholes in the system and somehow get out of it. So that can be seen even in Sri Lanka. You see certain large scale corruption not being dealt with properly, but then a person stealing two coconuts would be dealt with seriously, right? So you always see a gap. When there is a gap in power, people don't believe that law applies equally, right? So that is actually an attitude towards rules which is often influenced by the power distance. Then, if you move into human nature orientation, now there are two types of HNOs. There are societies with a positive HNO where people actually can be trusted to obey the rules. You don't have to enforce law on them. They understand why there is a particular law, and then they will be quite positive towards those rules. They understand why there is a regulation, right? But negative HNO countries, people actually don't understand the reason behind the rules, so you need to enforce rules on them. You can't assume that people would obey the rules. You need to enforce it on them. So if I ask you a question, where will Sri Lanka fall into? Sri Lanka will fall into a negative HNO because if you guys can remember the seatbelt laws, right? When it was initially enforced, there was a lot of enforcement that was required, right? People didn't understand why there is this regulation to put on the seatbelts. It is for your own safety, but you don't understand that aspect. But you wait till somebody enforces a fine on you. So that's how negative HNO countries work. Now, if you take these recent developments in the country, how much you tell people to be inside their houses, don't come out, don't associate with other people, maintain social distancing. People don't understand. It needs to be enforced on them. As long as there is no penalty, as long as there is no jurisdiction, people would not understand the gravity of the rule, right? So this applies to many things. If you look at the color light, right, when uh, the 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 change in the color lights from green to yellow, in many other societies people apply brakes and stop, right? But what we do is we try to somehow see whether there are any cops, right? If there aren't any cops, you quickly accelerate and try to jump the red light. So we don't understand the gravity of the regulation unless there is strict enforcement. So there has to be a cop to enforce the rule if you are living in a negative HNO country. But in positive HNO countries, it is understood that people can be trusted to obey the rules, and they will understand why these rules exist in the first place. So this is, I think, the final slide. The strategic approaches to regulatory change. What can we do now when there is a regulatory change which applies to you? The first thing you might do is you might have to comply with that regulatory change and just change your business activities, change the way you do things, and comply with the new law, right? But then there are alternative approaches to regulatory change. Now, how you come up to these alternative approaches would be by asking two important questions, right? The first question is regulation important for the firm? So if the regulation is important for the firm, you ask the second question, which is firm relatively powerful, right? So if the regulation is important for the firm, and if the firm is relatively powerful, then you might be able to alter the regulation, right? So, if I give you an example now, how do you assess whether the firm is relatively powerful? Mainly, the indicators would be how big your company is in terms of revenue, how much of taxes you pay, how many jobs you have created. So, if you're a big company and you're very powerful, you have bargaining power, then you might be able to talk to the government and alter the regulatory change. Now, that's an option that is available. But if your company is not powerful enough as a single entity, what you should be doing is you need to be forming allies. Right? So that is the second box that you see. If the regulation is important for the firm and if the firm is not powerful, then the firm will have to partner with other companies in the same industry who has a problem. Right? So we call that ally. So if you look at the apparel manufacturers, they have the Joint Apparel Manufacturers Federation. We call it the JAF, right? So JAF, what they do is, as single entities, if they go and talk to the government might not change certain regulations. So they will get together as an alliance and they go and lobby with the government to change regulations and all that, right? So the first option that you have is if you're a relatively powerful company, then you can alter the regulation. But if you're not relatively powerful, but it still impacts your business, then you will have to form an alliance. You have to ally with other similar companies in the industry and lobby with the government. So that those two are strategic approaches that are available. Then, if you look at the second area, is regulation important for the firm? And the answer is no. The regulation is not that important for the firm. And the firm is relatively powerful, then you can avoid because the regulation is not important for the company and you are a powerful entity. Then you can probably avoid the regulation because it doesn't have a big impact on your business. But then, if as a company you are relatively less powerful, then you will have to accede. Accede is you will have to abide by the regulatory change and change the way you do things. Right? So, these are the strategic approaches that are available for you to um, use when there is a regulatory. So that's about it. So go through chapter 4 again, go through political environment and legal environments, and if there are any questions that you come across, please do reach out to me on Facebook, and I'll try to uh, guide you accordingly. Thank you very much.